everyone, and welcome to another live session with immigration. Hello, everyone, and welcome to another live session with immigrationquestions.com. In each episode, we discuss important topics for immigrants, both documented and undocumented, focusing on their legal status in the United States. We aim to answer as many of your immigration questions as possible. My name is Nikita, and I'll be your host for today. Before we dive into today's topic, let's start with some basics. Many people work hard in the United States with the goal of making it their permanent home. If that's you or someone you know, we've got great news. You can obtain permanent residency through an employment based green card, and today we'll discuss how. Today's topic, securing permanent employment, a step by step guide. It's designed to break down the employment based green card process into simple, clear steps. It's not just about meeting deadlines, it's about understanding where you fit in and making smart decisions along the way. To walk us through this process is a certified immigration law expert with over 40 years of experience. He is well known for his work in business immigration law and has recognized as a super lawyer since 2008. He also holds the Martindale Hubbledale AV preeminence rating for his ethics and legal skills. Please join me in welcoming attorney Gerard Chapman. We're so glad to have you here, Attorney Chapman.
Thank you very much. It's a pleasure to be here, Nikita, and thank you for your kind introduction. And I'm in no position to disagree with anything you've said.
Thank you. So, to our audience watching on various platforms, it's about to get exciting. So, grab your notepads and pens as we get started. Attorney Chapman, for those hearing about employment based green cards for the first time, could you give us an overview of different categories like EB1, EB2, so on? And how do people figure out which categories would be best for them?
I'll do my best to give you a nice synopsis of that. These categories are designed to allow employers and sometimes the employee by his or herself to obtain permanent residence, and they're very, very fact intensive. A lot of people think that the law is the most important thing, and it is very important, but the facts are truly the thing that controls whether or not you're able to obtain permanent resident status in the employment-based system. The EB1 is really broken into three categories. The EB1A is for extraordinary ability workers, people who, I sort of kid around and say, well, if you won the Nobel Peace Prize recently, we can probably do that for you. The second part of that first preference is for outstanding professors and researchers. The third part of that first preference is for international managers and executives who've been transferred or wish to be transferred to the United States. The EB2 category has two subparts. One is for people with advanced degrees. The other is for exceptional ability. And in either situation, the individual can ask for a national interest waiver, which would, we'll talk about that just real briefly in a little bit. The EB3 is broken into three subcategories: professionals with a bachelor's degree, skilled workers who are being sponsored for a job that requires at least 2 years of experience, and unskilled workers, so a job that would require less than 2 years of experience. So that's the big overview of those categories. In the first preference, which we described a minute ago, none of those categories require the individual or the company really to go through what's called PERM, or labor certification. So it's highly desirable from that standpoint. Conversely, these categories are much tougher to succeed in. So there's a plus and a minus with those. You can also exempt out the PERM or the labor cert if you are eligible for and convince the Immigration Service that you should have the national interest waiver. That also can be very, very difficult. But if you can avoid the labor cert, you've saved a tremendous amount of time and expense for the employer. Even though some of these other categories are not as tough to be successful, many of them have very, very large backlogs. And to that extent, a lot of the time it's a very good thing if you can avoid that labor cert, because that tends to be in categories where there's a big backlog. So that's the big overview. Are there any other particular points that you would like me to try to address as far as those go?
Yes, you mentioned perm. So, what is perm, and why is it such a key part in this process?
Okay.
And if you have any tips to getting through them smoothly.
Okay. Well, one is be very patient because it takes forever. And I would say this in terms of timing with all of these categories, and frankly, with every kind of immigration case, whether it's a business or a family based, expect everything to slow down. All of these categories are going to be impacted by the enforcement only mentality that the new administration is going to bring to the table. And background checks are going to be very much part of the case. There are going to be interviews in employment-based cases. We had that for a while during the first Trump administration. It didn't continue during Biden's administration, but that's going to come back, I believe. So patience is going to be a huge part of this, and being very, very clear with your clients, keeping their expectations reasonable is going to be very, very important. Okay, the PERM process, where it is required, not all cases required, but where it is required, the first step of that, well, what it is, it's a test of the labor market, and it's a way for the employer to show that it has done what it can to discover if there are any qualified U.S. workers who are willing and able to take the job at the prevailing wage that the Department of Labor tells the employer it must offer for this job. The prevailing wage is actually the first step in that PERM process, and it requires identification of the job, the minimum qualifications based on education and experience and so on. You send that to the Department of Labor, and in about a year, you get an answer. The process does not take a year. It's just that the Department of Labor is horribly understaffed, and that's going to probably, again, it's probably going to slow down. But you really should not do anything else until you get the prevailing wage. The reason for that is for professional positions, for instance, you have to do 6 different types of recruitment, and in at least one, sometimes 2, you have to put the prevailing wage. So if you do any of your recruitment before you get the prevailing wage, you may have wasted time and expense and a lot of effort for nothing. So you really should wait until you get that. Once you get it, you do about, again, for professional positions, about 6 different kinds of recruitment. If you are successful and you can show that you couldn't find a qualified U.S. worker, that allows you to file the PERM case, which again is going to take about another year before you get a decision, unless you get an audit. And if you get an audit, that's going to stretch out several more months. But all these time frames, like I said, are probably going to extend out. They're going to slow down. For cases where a PERM is required, you have to get the PERM approved before you can file the immigrant visa petition. And in fact, you have to file that immigrant visa petition within 180 days of receiving that approval from the Department of Labor.
Okay, say someone has navigated through perm successfully, and they're obviously going to come across the I-140 and the I-485 applications. What are the documents that would be needed, and what are the timelines people should keep in mind?
Okay, one very important point to keep in mind is that the I-140, the immigrant visa petition, which is step two, and the adjustment of status, which is filed on Form I-485 for people that are in the United States who are going to finish their case, those may or may not be able to be filed concurrently. Whether they can be filed concurrently depends on whether or not there's a backlog in the category for the individual employee. For citizens of India, for instance, the backlogs sometimes go back to 2012 in some of these types of cases. And as a result, if you're filing the case, the Department of Labor process, the PERM case, if you're filing that tomorrow, there's not going to be the backlog will still be there when it's time to file the immigrant visa petition. So you cannot file those concurrently. Um, for the immigrant visa petition, you basically are needing to prove that you got the approved labor cert and that you have a job that is available for the individual, that the job requires whatever you put on the labor cert, and the individual has that set of qualifications and had them before the company hired that person, typically with a temporary work visa. And you have to be able to show that the company has had and continues to have the ability to pay the prevailing wage. So that's a general description of all the documentation that's required for the I-140. When you get to the I-485 stage, you're typically proving that the employer continues to have the ability to pay the wage. And other documentation relates to the individual employees having been in proper status all the way through the entire time he or she has been in the United States. And hopefully you have figured that out long before you even start this PERM process, as well as figuring out, does a person have those qualifications and did he or she have them before he or she was hired? So an initial look at everybody's qualifications, what the job is and so on, and the ability to pay at the very beginning of the case, and alerting the employer to all those issues is very important.
Yes, yes, of course. Every process has its challenges, and employment based immigration is no different. But, Attorney Chapman, what are some of the common mistakes applicants make, and how can they avoid this pitfalls?
Well, like I said a second ago, maintaining proper non-immigrant status is one of the huge issues in these employment-based cases. If you're going to finish it here in the United States through adjustment of status, you must be able to show that. Sometimes the employer is a little bit optimistic about the ability to pay, and being sure that that ability exists at the very beginning of the case is tremendously important. Sometimes the employer has on file a prior employee confirmation letter of a person's prior employment that is a little bit too general. And obtaining copies of those letters at the very beginning of the case is extremely important if some amount of experience is required. Those are probably some of the more common errors that we see in these cases, and we do our best to try to avoid those at the very beginning of the case. And sometimes having an employer invested in that initial work becomes a bit of a challenge. And you'll get the answer, well, I think I can get that for you in the next 2 weeks. Let's go ahead and just start our process now. And you don't want to, turn a client away, but it's really important to exert some client control as well.
Okay. So if you are just tuning in from any social media platform, thank you for joining us. We're excited to have Attorney Chapman with us today, a respected immigration attorney who has contributed greatly to today's topic. This is immigrationquestions.com, a platform designed to simplify the immigration process. Ask your immigration questions for free in any language and get connected with a verified attorney who can offer legal guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestions.com and sign up today. Attorney Chapman, for um, a platform that seeks to aid the immigration journey of every immigrant, both documented and undocumented, by connecting them with seasoned immigration attorneys like yourself. What do you think of immigrationquestions.com and what we do for the immigrant community?
Well, I think the service that you offer is basically a good one. It is very important to be working with an attorney who has experience in this area. This is probably the most complicated area of U.S. law, period. I'd say the tax laws are probably close, but not as complicated. And with this administration that is getting ready to come into power on January the 20th, we expect a lot of changes that typically, unless the attorney is doing this all the time, you can't keep up with it. So that's an extremely important issue to deal with when at the very beginning of any relationship with an attorney in this area. You want to make sure the attorney has been doing this on a regular basis for quite some time.
Brilliant. This has been such an insightful conversation. To our audience, the floor is now open for questions and answers. Please feel free to type your questions into the chat box, and we'll try to address as many as possible. If you want to join us live or call us live, uh, ask your questions directly and call in the number 516 703 3483. Attorney Chapman, before we get into the live Q&A, let's discuss a common challenge. Sometimes, even when everything goes right and everything is done right, cases can still get stuck and face delays. What advice would you give someone in that situation?
That's a very good question. Our advice typically is, and especially now, expect these delays. And to the extent that there are limited time periods with temporary visa categories, real early planning is critical. And when you talk about planning, you're talking about the employee, the HR manager, who typically is going to be in charge of the immigration issues and immigration cases, and the supervisor of that individual employee. All of those people are very important stakeholders, and they need to help do the planning at the very beginning of the process. Really, there's some real tension here. A person who's hired and has a temporary visa that allows them to work, it may be difficult to figure out from the employer standpoint right off the bat if this is a good fit, and same for the employee. But because these timeframes are going to be so slow, the delays are going to be increasing. It's going to put some pressure on everybody to make decisions earlier than they might want to. So that's a tension that everybody needs to be aware of.
Okay, that sounds insightful. So I'm just waiting on questions to come through.
Right, I saw
We
one
have a
earlier.
question from Shana
There we go.
Cruz. Yes, we have a question from Shana Cruz. My work visa will expire very soon, and my employer have not started the green card process. What do I do to continue staying in the United States legally before I get permanent residency?
Well, there's a couple options you could look at. One would be to apply to, and I'm assuming we're talking about, there's no way to extend this person's temporary visa. A person can apply for admission to a university here in the United States and do a change of status to F1. During that time, you need to be a full-time student in order to be proper, to follow all the rules properly for F1 status. But that can give you a way to sort of park here in the United States while your employer, hopefully, or another employer pursues permanent resident status for you. There are some other categories of visa that do allow work, for instance, the J1 for people who, there's a sort of a broad array of different kinds of employment that a J1 can do. But you need to be real careful because with some countries, there is a 2-year home country requirement so that a person actually has to go back to the home country for 2 years. unless a waiver is approved. And that can be done, but there's no guarantee by any means that you can get a waiver. Um, Really, the answer to the question is it really depends on your facts. And those facts may provide different options or alternatives for one person versus another. But going to school or a J1, or there may be a family-based option if the person's married to a citizen or permanent resident. There may be a green card route through the family-based process as well.
Okay. Shana Cruz, I hope that answers your question. We have a question from Philomenia Uba. Which type of jobs make it easier to get a green card?
That's a great question too. If a perm process is required, then the more difficult it is for anybody to qualify for that job, whether it's the foreign citizen or a U.S. worker, it doesn't matter. But the tougher it is to qualify for that job, then the higher your chances of getting your perm approved. If it's a job that, or if it's a case that does not require a perm, then the job has to be one that would fit inside these various first preference categories: the extraordinary ability, the outstanding professor, and the international manager, subject to transfer categories. If it's an EB2 advanced degree case and you're looking for the national interest waiver, then what I would recommend that you do is to look at the case in re Dhanasar. That's DHANASAR. That will tell you what the Immigration Service typically looks for in a national interest waiver case. So it really is fact dependent. I think I've said this maybe a couple of times, but your facts really determine what category of green card case you're going to qualify for if you do. So I'd really rest on that answer.
That sounds great. I've also got another question from Rogers. I lost my job and my green card application was sponsored by my employer. Can I continue the process with another employer or will I need to start again?
Well, if you are going to move to another employer, then that employer is going to need to start over. And because it's a different job with a different employer, and it could be in a different part of the country. So the perm process basically carves out one job for one employer in one location. And if you move outside of that, then you do have to start over. One important issue to keep in mind is if you have already gotten your perm approved and you've gotten the immigrant visa petition approved, you have what we call a priority date. In other words, you have a place in line, and you keep that place in line if you've gotten approvals on step 1 and step 2. If you have not gotten approvals on both of those steps, then not only does the new employer have to start over, but you go to the back of the line. So hopefully you've gotten first 2 parts approved.
So once they got the 2 parts approved, they won't have to wait in line as long.
Yes, there may still be a substantial backlog, but at least you don't start over.
Okay, on to our next question. Ibrahim Basar. If I get a green card through my job, how long will it take for my wife and child to get their own green cards?
Typically, they will be able to process with you. And the children have to be under 21, though, for the case to be approved for them. With some of these backlogs, it can be very, very difficult to get that approval before the children turn 21. But as long as they're under 21 and as long as the parties are married, the green card for the family members would be approved at the same time as the green card's approved for the principal non-citizen.
And assuming the family's green card will be valid as long as his green card is valid, am I right?
As long as what?
As long as his job green card is valid.
Yeah, permanent resident status exists. Once you're approved, your status exists indefinitely. Your card will expire, but your status, unless you do something that causes you to lose your status, will continue to exist. So you need to renew your card or file for citizenship when you're eligible for that if you choose to do so. But the status continues.
Okay. Moving on to our next question, Ayesha. How long will it take to get permanent residency through employment, and what can I do to avoid delay?
Okay, I'm going to take them in reverse order. You're not going to be able to avoid delay. What you can do though is start as soon as possible. You know, you and the employer need to sit down and have that very important discussion of when to start the green card case, and hopefully you can do that early. So that's the best defense against problems with delay. In terms of how long it will take, it depends on what country you're from and what category of green card case you're using, because the different countries have different backlogs.
Okay. Um, I think that's all our questions. Oh, we've got another one. Kalimi, I work for a freelancer. Can I get a green card through employment, or do I have to get a full-time job?
I would say again, it depends on your facts. Some self-employed people are able to qualify for one of those, extraordinary ability or outstanding researcher types of positions. The outstanding researcher and professor do require a job offer. The extraordinary ability does not, nor does a person who's got an advanced degree and can get the national interest waiver. So it depends, but those are difficult to achieve success. So you need to be careful that you're not trying to do something that you're really not qualified to do.
Okay, so that answers that question. Um, just going to see if we're getting any other questions coming through before we move on. Okay, I think that was our last question. So, what a great way to end today's session. Thank you so much for joining us, and a special thanks to our guest speaker for sharing his time and expertise. We look forward to
You're very
having you
welcome.
back. We hope today's webinar helped answer your questions about securing permanent residency through employment. Visit immigrationquestions.com to connect with experienced immigration attorneys who can guide you through your journey. If you missed any part of today's session and want to listen again, the recording will be available on Spotify. To catch today's episode or any past ones, just search Borderless Talk by immigrationquestions.com. Join us next week for another great session on employment based immigration. We'll be joined by attorney Andrea Bowers, who will discuss how to secure a green card without family sponsorship. Spotlight on the EB2 NIW. You won't want to miss it. Once again, thank you, Attorney Chapman, for
Thank you.
making today's session so exciting. We can't wait to have you back.
Thank you so much.
Have a wonderful afternoon and see you next week. Stay informed and empowered on your immigration questions and journey. Thank you.